Welcome to the Men's Divorce Podcast, presented by the domestic litigation firm Cordell Cordell, a partner men can count on. Now, here's your host, Managing Partner and CEO of Cordell Cordell, Scott Trout.
Well, welcome everyone. It's Scott Trout here with Cordell Cordell. I'm the CEO and Managing Partner. And welcome to part 2 of our ongoing series of a 4-part series where we talk a lot about divorce. Last time in part 1, we talked about my wife, or I am thinking about divorce and what do we do. And today, we're going to talk about my wife has filed, now what? You know, many guys face that proposition that they are either divorced they didn't know, they didn't expect, or they don't want. And again, we want to really just talk generally about thoughts and tips that we can give guys based upon our collective experience at Cordell Cordell. Not legal advice, keep in mind. We're not going to give you legal advice because there's just too many facts and circumstances that would dictate. And obviously, I'm licensed in Missouri and Illinois and Georgia only. And guys out there I know around the country in states that I'm not licensed in, and my guests are typically as well. And so I've got a guest today from Cordell Cordell, Erin Zielinski. I'm going to have you introduce yourself, tell us a little bit about yourself, and then we'll get right into the meat.
I'm Erin Zielinski. I am a senior litigator at Cordell Cordell. I've been with the firm for almost 2 years, but I've been practicing in the state of Missouri for 17 years this year. Well,
I'm looking forward to giving guys out there a lot of info because they often come in and say, I didn't see this coming. Now, questionable whether they should have, right? And then obviously in part 1, if they had any hint of it, they should be practicing or preparing and strategizing about it. So let's start. Guy comes in the door and says, hey, I didn't know it was coming. She filed. Question I always ask is, were you served, right? So what happens after you ask that question, and what else would you ask a guy originally or initially as they come in the door?
Well, it is pretty shocking, especially if they didn't know it was coming. So a lot of times it's just sitting listening and try to get a little bit of a background as to what's going on. If he has been served, typically he will have brought the packet, the summons packet with him. We will go through that packet together, see what allegations are being made, if it's a question of alimony or maintenance, child support. It's very overwhelming. So it's typically just sitting down, trying to calm some nerves and figuring out where to go from there.
Right.
And walking through that process.
So there are all kinds of timelines that are critically important to guys. So guys are out there saying we oftentimes, lawyers, we throw legal terms out there that no one understands, like served. What does it mean? And if a guy comes in with the papers and you ask him, well, have you been served? And what does that mean? So tell guys out there, what does it mean to be served?
So if there's a knock at the door and a man stands there and hands you a packet, and it's a petition for dissolution of marriage in the state of Missouri, then he's been served, and I would explain that you've officially been served. So now, in our state, you have 30 days to respond to that packet, and you have to file certain pleadings or documents in response to your wife's petition for divorce.
So I'll just play guy out there. My wife gave this to me. And she said, I don't need to worry about it. Or let me take it even a step further. A guy did come to the door. I don't know who he was. He was in regular clothing. It could have been a friend. He said, consider yourself served. But my wife said, don't worry about it. I'm working with my lawyer. He said, you don't have to worry about it. And it's 29 days ago. Do I need to be worried about it?
You need to be really worried about it.
So what steps do I take? What do I do? And why do I need to be worried? What can happen to me? I mean, she promised me. I mean, she said, hey, honey, I want to work this out. I really don't want to go forward with it. But she hasn't dismissed it or done anything to make it go away.
So if it is, in fact, 29 days ago that you were served or that she hands you a packet or whatever it was told to you, I say in almost every meeting with a gentleman who's been served, that you will hear things that your wife will tell you constantly over the process of a divorce. 99% of the time, it's not true, it's not factual, and it's just a way to sort of manipulate the situation. It is imperative to get yourself an attorney as quickly as possible, but also to pick an attorney that you're comfortable with, And that explains this process too, because it is incredibly overwhelming. Something like a timeline, like these 29 days. If you do not respond within those 30 days, your wife could get a default judgment against you. And you don't want that to happen. It would be a judgment she would try and get entered by a judge, dividing your property, awarding maintenance or child support or custody, and you would have nothing to do with it because the court doesn't see where there's been anything filed by you.
So they can proceed without him.
Absolutely.
And they will.
Absolutely.
What are the chances of getting it set aside? If I just sit on my rights because she told me, I don't have to worry about it.
So in the state of Missouri and in the jurisdictions that I practice, if something like that were to happen and there is a judgment entered, the court and the judges, in my opinion and in my experience, tend to set them aside because they don't want a default judgment entered. They would rather give the parties the opportunity to litigate the case for a fair settlement. So if you have any sort of excuse or legal or otherwise, the judges will tend to set them aside. But it's absolutely not something you want to risk.
And don't rely on it, right?
Absolutely not.
So if she just hands it to me, I've always told guys, if your wife hands you documents, even if it's not served, you need to go see a lawyer. I mean, it's always protect your rights by at least getting the information that you need and to know what you should do, right? So they should, first thing to do, next day, call their lawyer, right?
Call a lawyer, yep.
Right. And so as, you know, during that conversation, I've had guys say, well, my wife said, hey, let's use one lawyer. My guy's really good. It's all he does. And he said he can handle it for us both. And it'll cost us half the amount. Should the guy use one lawyer every time?
I would say rarely, if ever,
Right.
to use one lawyer. If it's an amicable situation and you knew it was coming and it's something the two of you talked about and there's no issues involved, maybe, but even then I would still highly recommend getting a lawyer just to protect your rights.
Yeah.
So, and there are so many issues at stake, and one lawyer cannot adequately and really shouldn't be representing both of you.
Yeah. I've always said to guys, here's the caution. If you fall into that trap and you agree that, you know, because it's incenting to want to spend half the amount of money or even, 20% of the money because she's got a lawyer and you go, I'll just settle it. That lawyer cannot represent your interest, will not represent your interest. And if they do, I think there's an ethical issue. Because I've told my clients, similar, where I'm all for, and we'll get into that a little bit about preparing an offer. And if she wants to retain counsel, fine. If not, that's okay as well. But I will refuse to meet with them. I will not speak with them. I don't want to meet with them in our office. They can't come to my office. I don't want to even give what I call a scintilla of anything that suggests that I represent their interests or going to change anything for them because I represent one person and that's it. And so think about it this way. Do you want to risk everything you've earned, worked for, your property, your retirement, your kids on someone who is not looking out for your best interest at all? Is that really worth it? And so in part one, we spoke a little bit about it's the best $200 you ever will spend to just go get some advice. It's not $2,000, it's $200, just to see, do I need a lawyer? I mean, resoundingly, we're always going to say yes, because there's so many things from a guy's perspective that, whether it be tax consequences and tax deductions on kids or the effects on the division of property, whatever it may be, your surviving spouse rights on retirement that you're not thinking about. Even if she says, we should use one, the answer should always be no. I mean,
Right.
in my mind, always.
And it also goes back to where, one party, and because I mainly represent men at this point, but, if the other party, if the wife is telling you things and telling you as if it's fact or it's law, and you haven't gone to check to verify if any of those things are true, and then it comes to a point where you're handed a document that is dividing everything you've ever worked for, and all you've taken is the word of your wife who served you with a divorce.
Yep.
So she's looking out for her best interest. She is certainly not looking out for yours. So again, just to get, it's 1 hour out of a day for $200,
Yep.
and it's absolutely worth it.
I give guys a visual. I do this seminar around the country, 10 stupidest mistakes guys make when facing divorce. And I give them a visual that kind of puts this in perspective. And that is, when you got married, you're sitting next to each other and at the long table, and you're looking out on your family and friends. You're on the same side of the table. Now that she's served you, you're at opposite sides of the table. It's almost like a negotiation. Now she has her interests on one side, and you have yours on the other. It is a very different dynamic, and you need to treat it as such, and that you're not as one working together. You're now separate. And so keep that in mind. As wonderful as your relationship may still be, as cordial and cooperative as you anticipate this thing to go, it is to treat it with the respect that it deserves, and that is have someone give you recommendations. If you were diagnosed with a disease, you wouldn't treat yourself. Yeah, or you wouldn't Google it and then try to do your own treatment plan. You'd go get some advice from a doctor, wouldn't you?
Exactly.
Yeah. So one of the things, most guys come in, and this makes the presumption that, she's filed and you're still living together, because I would say the super majority of guys that I see, in cases I see, they are still living together early on because they're financial reasons for the most part. The question is do I move out? As a guy, what do you recommend? Should they move out, and are there consequences, advantages? What do you think?
So that question comes up at every single meeting, and I generally say do not move out. If you can remain in the house, stay in the house as long as possible. Figure out some way to make it work. I've had clients who say, well, I stay down in the basement during certain days and she stays upstairs. And then they just sort of come upstairs to take care of the kids for those 2 or 3 days and then swap. Mm-hmm. It's not easy. It's not convenient, but I think it's necessary. It's not permanent. So there's always sort of the light at the end of the tunnel. We just got to get through a few months of the beginning of the divorce. Oftentimes it can go through the entire divorce, but that's not preferred. In the beginning of the divorce, you can file motions. You can ask the court for some relief on these issues, like living in the same house. Because if you move, you've got, especially if there's kids involved, the person remaining in the home with the kids is automatically going to have the upper hand. And then you are going to be left having to beg for custody of your children. And there's no court order in place that orders her to turn them over to you. And it could be 4 weeks, 6 weeks before we can get in front of a judge on this. So immediately you put yourself at a disadvantage if you move.
Yeah, that's a huge point, because the very first question is, what advantage do you gain? Divorce by nature is an irrational thing. Oftentimes. There are very rational decisions to do it, whether it be domestic violence, whatever it may be. But it causes people to make irrational and very quick, irrational decisions. And so before you do anything you do, it should be, what advantage do I gain, and do I gain control in my case? And specifically, whether you have kids or no kids, I always say that the decision, I think, is the same unless you can get control. Because there are huge consequences by moving out. And, I'll just throw one out, and that could be double household expenses. If you're the breadwinner and you move out and you leave the kids behind in that, with mom, and if I'm mom's lawyer, I'm going to say stop paying the bills. Force him to pay the bills. He's the breadwinner. Or she takes all the money out of the checking account. You kind of lose control. You've gone from a wonderful home to a one-bedroom apartment with no furniture, perhaps, maybe an air mattress on the floor, so you really can't even have custody because you have nowhere for your kids to sleep. And now you're paying for your wife to live in your home and her boyfriend maybe. You can think of the scenarios in which that decision becomes an irrational one to move out because the consequences are so drastic. And so I've often told guys, think about it as it relates to kids. There's parental alienation issues. And if you don't know what that is, I'd encourage you to look it up, parental alienation syndrome. It's something that you should have a conversation with your lawyer about, or double household expenses, whether you have kids or not. They're just a consequence to every action that I see in divorce. And so I do see the decision, and it should be a question that you have with your lawyer. Again, often, and I agree with Aaron, that I always say don't move out, absent domestic violence, safety issues. But don't, take that for gospel from us today. It's just, again, everything we talk about today should be used as a basis to form questions that you have when you seek out counsel. But they are based upon our collective experience.
To the flip end of that, in terms of never moving out, and you mentioned the domestic violence, I find, and I sadly, I find it more and more often, that if the parties stay in the same house, there is sort of this exception, and that is, I have found that women or the wives will go and get an order of protection completely unjustified, completely based on false allegations, and the only reason it's done is to get the husband out of the house. It's very unfortunate because it's very difficult to undo it once it's done. Even if you prove and you get it dismissed, it's an entirely separate court date. It's in a different division, well, at least in where we practice. And it's just difficult. It adds a whole new level of complication to the divorce.
Yeah.
So if that's the case, that's the other question I'll ask. What is it like in the house? Do you have this fear? Do you think it's something she would be capable of doing? And like you said, it's such an irrational time. It's an emotional time. People don't act like they would normally act. But if you think that is something that she would do or that she could do, then consider it.
Yeah.
Because you don't want to end up getting an order of protection against you and having this whole new complication if you are able to leave.
Yeah. That's one of the mistakes we talk about in our evening seminars or even our live webinar over lunch hour, is allowing confrontations to occur and or escalate. And that is, it's a great point to talk about what's it like in the house. Are you guys arguing constantly? Because I agree wholeheartedly that as it sits, at least in Missouri and Illinois and Georgia, the statutes and the law as it relates to the ability to get an order of protection, and in some states, without even a notice, and you have an hour to get to court to defend yourself against allegations that judges aren't risk takers. If the wife says he threatened to kill me, and you weren't even there, judge is going to probably enter the order absent some direct, clear, and convincing evidence to the contrary. They just don't want to be on the news that says that somebody actually took action the next day when you denied an order of protection.
That's exactly right. I also say if that's the environment within the house, here you can record. If you're doing the recording, I will encourage the guy to start recording if there's fights and I don't like doing it's not something I would encourage someone to do. It really does take a certain set of circumstances, like allegations of domestic violence, but start recording if you think it's a possibility. I also tell the guys, hey, texts are golden in court. In our courts, if you can print out your text messages where, if she runs and tries to get an order of protection and you come to court and have text messages where, she's asking you what's for dinner, then, chances are she doesn't feel threatened.
Yeah.
And you can show those to the court and you very easily get that order of protection thrown out. So text messages are so important. So in that initial consult, part of that consult is telling them what to do now. What step in the interim before that day of your consult and whatever next step you're going to take, start being just aware of everything you have in terms of text messages, videos, bank statements that are coming in. Keep a journal, just so that there's clarity later on because the divorce process can take some time.
Yeah. It's do nothing that gives her an advantage or control in the case. Because, again, it's like when I talk about the allowing confrontations to occur, and that is, there is no argument that you're going to win. If you're headed to the divorce, you will never win that argument, and it's not worth it. And whatever your spouse does to bait you into a conversation that becomes an argument, just walk away.
Right.
Let your lawyers handle it. You're not there to win it because you won't win it. In fact, the only thing you'll win is an order of protection.
Yes.
You'll win the ability to get 5 minutes to gather what you can in your hands when the sheriff's waiting for you outside to escort you away from your property to which you will never get back into.
Correct.
It's not fun. And so, moving out, if you can move out with the kids and gain control, by all means, we suggest you do it, obviously. Again, it's one of those things where what we're talking about today and everything we do in this 4-part series, again, is just want you to have a conversation. The questions that many guys don't think about, the issues that many guys don't consider, this is what we're doing today, just so you go to your lawyer, whether it's at Cordell Cordell or whether it's somewhere else who does family law. In part one, we talked about the lawyer that you should look for and what's important. Again, write these down and say, hey, you know what I heard on this podcast? I shouldn't move out. What do you think? And I think that's key. So as you think about moving out, in those same in that same arena, do you suggest to guys in any way that they should preserve any documents, whether it be tax returns, pay stubs, 401k, anything important? I think you mentioned it earlier about if you don't have it, it costs us money and time to get it. So what would you suggest to guys out there? Wife is filed. They're still living together. Do you suggest they go and preserve something, put it off-site? What do you suggest?
If they are able or he's able to do that, absolutely. It would be very beneficial. Ultimately, for something like tax returns, bank statements, we'll be able to get them. It's just a more expensive route. We have to send out subpoenas or discovery requests. It just becomes more than it needs to be if he is able to obtain those from the very beginning. If you can bring them to your office or give them to a friend, a family member, hey, hold on to these for a bit, or give them to your lawyer. I mean, if you filed and you're in it, you can hand it all over to your lawyer as soon as you find it or collect it. And then the lawyer will keep it and likely exchange it with the other attorney. In Missouri, we are required to. There's certain documents that we have to exchange. So if he's able to get them in the beginning, it just makes it easier moving forward.
In part one, we talked a little bit about the things, what I call attorney savings opportunities. And the more prepared you are, the less we have to spend. And I think it's key. Gather what you can, even move them off-site, but give them to your lawyer. It's just better because ultimately we do have to exchange them and we can keep them. And I think it's important. Inventorying property. I've talked a lot about this in my webinars and in my seminars. You're still living together, but in the event that you get kicked out, what do you tell guys about property? While they're still able to inventory, if they're still living together, what do you tell them to do?
If they're still living together and he's moving and he plans.
Or they may get kicked out or they may be moving out, whether it's an inventory or taking property. What do you tell guys? What do I do? Do I just leave with my clothes and do nothing? Or do I walk through the house, take what I can, take what I want? Or do I just record it all so I know what's there?
I advise a little of both. So if the divorce process is happening, everybody's in court, everybody's got a lawyer, and we're in process of your divorce. In the very beginning, I would take the inventory. You can even record it. You don't even have to write everything down. You can just walk through the house with your camera, open drawers, open closets, open boxes, and just get an idea of everything that's there. Because let's say at some point you have to leave the house. I can't even tell you how many cases I have pending right now where they haven't been in the house in 8, 9, 10 months. They don't know what's there. They don't know what's been moved. And they haven't been in the house in so long, they can't possibly remember. Yeah. So, or, the wife is spiteful and the things are destroyed and the house is in such disarray that you don't know what's there or not there. I mean, it's crazy what can be done during the divorce process. So be proactive. I think that's key. Proactive throughout your entire case. Take an inventory if you can. Write it down, do a video, then create a list of what you want. Out of all your marital possessions, what is it that you want to walk out of that house with if you are the one that has to move? Yep. And then give that list to your lawyer. And your lawyer, and I think we might be talking about this later, but if your lawyer sends over a settlement letter at some point during this process, you want to try to negotiate a settlement, property or household goods, personal property is a part or subsection of that settlement. And I literally attach the list. Yep. Here's what he wants. When can he come get it? Yeah, that's a huge point. If you don't include it, you'll never see it again, even after divorce, because there's always this catchphrase, this catch-all that says if not delineated specifically herein, the person who has possession of the property retains possession of the property. Correct.
And you can say, well, that's my separate property. It's all my yearbooks from my high school. Well, too bad. Didn't list it out. She gets to keep it, right? I mean, it is what it is. That's why I tell guys, look, if you want it, list it. If you want it, take it if you're moving out. And if you don't want it, still list it because I want to know what she has. Some people, gloss over some of the most important, maybe valuable things. It could be artwork. It could be jewelry. There are some people that have quite a bit, and that all matters at the end of the day. We want to value everything. And so I think it's just so important as a consequence of moving out and not thinking about it is, I just left everything behind, and now I have no idea what's there, as you suggested. So the other thing guys ask is, she's filed. We're going to stay living together, but I contribute to my retirement. Should I continue to do so? Because of every dollar or every dollar I'm putting in there is going to be 50% hers. What do I do? What do you suggest?
So in terms of if she has filed in the state of Missouri, in specific counties, there's actually rules where you can't change. You can't go about changing this. Well, what they call it is the status quo. So you can't stop making mortgage payments. You can't stop making car payments or credit cards, and you can't incur a huge loan out of the blue. Everything has to stay the status quo. So if you've always contributed to your retirement and you immediately stop, and at some point the other attorney figures that out just by looking at your paycheck stubs, it just won't look good for you with the judge because it's clear what your intent was. Of course, the divorce is pending, and you don't want her to get any more than what she's already entitled to at the time she filed for divorce. But you have to weigh that up against what the judge is going to say when they see that you've done that. Yep.
And so the other thing I'd suggest guys do early on to kind of save a little bit of the money, because we know ultimately retirement in some fashion, it may or may not be divided. So I suggest to my clients, and every consult, is to gather the plan documents, whether from the administrator. So that way, there's something called a QDR, a Qualified Domestic Relations Order, for certain types of plans, like 401ks, things that are governed by what we call ERISA, that require a court order, a very specific court order that is consistent with what your plan suggests and how we divide it. Not a taxable consequence, so long as we don't withdraw money outside of another retirement account. But it just speeds the process up. So as guys come in the door, they filed, I will often suggest, hey, go to your plan administrator, go to your HR department and say, look, I just need the plan documents for my 401k so I know how to divide it upon divorce. And so it's just something I think about. But obviously, before divorce, that's a consideration. Nothing's been filed. Talk to your attorney about, should you be contributing to your retirement? Should you continue if that's ultimately what's going to happen? Knowing that 50% of everything or more may be given to her. But obviously, depending upon your state, whether or not there's a standing order that's entered that prohibits you from making any changes, do so. Again, another important conversation. Guys often ask, do I talk to my wife? Do I talk to her about the case? Do I negotiate with her without my lawyer? What do you recommend to guys do? Because oftentimes it's one of my topics that I do in the evening. It's called talking too much. I think there's a balance. What do you think guys should do if their spouse approaches them and wants to talk settlement?
So I always encourage, if things can be amicable, keep them amicable, because you can literally watch the cost of your divorce skyrocket with the more animosity and just almost to the point where many times it's like a pure hatred that happens over the course of the divorce. And unfortunately, that kind of contested litigation costs a lot of money. Or they just don't have that hatred for each other. They just don't want to be married. So then, of course, it's a lot easier to want to talk it out. Like, let's see if we can come to terms. I'm not opposed to that. I am opposed to, I will encourage them, don't ever, ever sign anything. If the two of you are sitting in the living room one night and just, hey, how about we make this all go away? What do you think about this? Nobody has to agree to anything. And then the next day you email me immediately. Hey, we talked. This is kind of what we were talking about. What do you think? And if it's bad, I will say, stop immediately. No more talking about that. That's not going to work. And I can explain I'll call him. This is why this isn't in your best interest. While I appreciate what you're trying to do, that's not in your best interest. So I don't necessarily discourage the talk. I don't think you should say too much, especially anything that he and I have talked about.
Right. Strategy.
Absolutely not. No strategy. But if it's just generalized talking, custody, I think, is a really good thing to talk about. Obviously, we always encourage 50-50. The state of Missouri that's the presumption is 50-50. So if they can agree to a 50-50 custody schedule earlier than later, that's fantastic. That's a huge battle that they can overcome that doesn't have to do with money,
right?
Which is much more complicated but less emotional.
When we talk about strategy, you'd mentioned one of the things I discuss at night is every guy's heard of, or every gal, Texas Hold'em, World Series of Poker. And I liken that to divorce, and I liken it to the relationship post-filing in this way. So you spend a lot of money with your attorney to develop a strategy, and the reason you do that is to try to create this roadmap that can get you from point A to point Z and put you in the best possible position to achieve your goals. There's no promises, no guarantees, right? But you want to be in the best position. So you spend a lot of money on your attorney who does domestic relations only, trying to get them exactly what they want. And so let's think about that like playing poker. So you sit down, you get your two cards face down, and you look at them, and they're both aces. No one's put any other money other than the blinds in. Who in their right mind would flop those aces over before anyone bets and say, look what I have a pair of aces, right? You wouldn't, because everybody at the table would just fold. And so all you get is a small blind and the big blind, and that's nothing. It's like this, in that why in the world would you share your divorce strategy with your spouse? Because that's what she wants. She wants to get out of you what you're planning. I tell a story about this, and really it's a sad story about a guy that did the exact thing. He shared his aces. And so you just have to take that approach that every time she's asking you about, let's talk about settling this, she wants to know more about what you're planning. And so I think that's a really valid point. It's a very important point. And I always think about themes when I talk about these types of things. And this is just called Texas Hold'em. And every time you have a conversation or she's trying to have a conversation, just think of Texas Hold'em that you have aces, and don't show your aces ever. You just play dumb and you listen. Listening is important. But also doesn't mean don't share. It doesn't mean don't talk. What it means is just be wary of what you're doing and try to settle it. Let your lawyer try and do it. Because that's just so key. Texas Hold'em, showing your aces is never a good idea. It never gives you the advantage unless there's a lot of money on the table already and you're going to get it. So,
right. The lawyers won't even do it. I mean,
right.
Trial's one thing, but which is when you'll show everything. But if you're in negotiation stage, you're going to put an offer that isn't going to look like anything the two of you talked about while trying to negotiate.
Totally. As we get towards the end of this Part 2 series, the guys always say, what role am I going to have in my kids' lives? Maybe you can briefly talk about the differences, and I know every state has some variances, and they may use some different terminology, but many guys don't understand what legal custody is compared to physical. You always talk about, I want custody. It is really broken out into two portions. Maybe you can just briefly, albeit from the position of Missouri, but it does apply in large part around the country. Just talk about the two differences and maybe not differences, but the two aspects of divorce and what role that guys may play in that.
So a dad is going to have as much access and as much of a role in the lives of his children as he wants, essentially, because then we're going to fight to make sure he can get that. Because essentially it should be 50-50. In terms of the sole custody versus physical custody, in the state of Missouri, physical custody just doesn't mean what it used to. It's physical. You can have 100%. You can have sole physical custody in the state of Missouri, and the other side can have 50% visitation. The case law over the last, it's maybe 10 years has changed it to where it just doesn't have a whole lot of meaning. That is not the same for legal custody. Legal custody has to do with any of the major medical, education, major decisions that are made on behalf of your kids. That is very significant. It's presumed, or it should be, joint legal. In the state of Missouri, if the parties cannot or will not co-parent and cannot communicate, then you would ask for sole legal custody, that one parent make all the decisions for the child because mom and dad can't communicate. They is incapable of coming up with a resolution between the two of them, so one party gets to make the call.
And what is legal custody?
Any major decision affecting the children, medical, education, the other one is right there, and I'm. It's just any.
I always say it's major medical and education.
In education,
there's general welfare stuff, but I mean, like extracurriculars have. Sometimes there's an agreement with extracurriculars, but it's the major stuff like surgeries, major medical stuff.
And medical it includes counseling and psychiatrists, and if there's going to be any aesthetic or cosmetic surgery, they have to agree. And you can even put in provisions about tattoos or piercings. I mean, those are major decisions. And,
choice of religion?
Oh, that's what it was.
Yep.
That's what it was. It was choice of religion, medical, or education.
Yeah. And it could be a choice of school. So they're going from high school or grade school to high school to college. And so that's really, many guys don't realize, and they give away something so important that is trying to do, you just don't want what I often see, meet and confer. Meet and confer means she's going to say, what do you think? Okay, I don't care. Hang up. And then she'll make the decision. You want meet, confer, and agree.
Right.
Right. So I think legal custody has more nowadays, considering, for example, Missouri is a 50-50 state from a physical custody perspective. You just want to make sure you shore up your legal custody provision if you have a settlement, and you just want to make sure that the language is tight enough that she has to, or you, if you're, the one, has to meet, confer, and agree. Because I think
in writing.
In writing, right? Exactly. Because I think you still want to play parent. You want to have those important roles on those important decisions. I mean, it's the simple ones on the day-to-day activities should be made with the parent who's having maybe that custody time. But it is the important ones. If they're going to go in for major surgery, both parents should have a say-so, and it's important. So many guys just have questions about legal and physical. Last thing, we talked process, timeline. We can skip the process probably. We did talk a little bit about that in part one. How long is it? Guys always like, I want a divorce. Can I get remarried in 2 weeks? It's that always, how fast can I get away from her? And that's always the question. And I know it varies state to state, but typically, here in Missouri, how long is it going to take if I can't agree? And how fast can I do it when we do agree?
So if you agree, and let's say you agree before you even file, that is fantastic news. So then we would file, you still have to file the petition for dissolution with the court with all the required pleadings that goes with that. You file it, and then in the state of Missouri, they call it a 30-day sort of cooling off period, that your petition for dissolution has to be on file for 30 days before a final judgment can be entered. And then everybody can sign it and it can be filed, and the day that judgment is signed, you're divorced. If it is contested, which is primarily what I deal with or what we deal with, if it is contested in the state of Missouri, and especially the jurisdictions we're in, the timeline is usually 9 to 12 months. In St. Louis County, the judges do not like to go past 12 months, so they are really strict about that timeline. It sounds like a very long time. It is a long time, and it's a hard period of time for everyone. But it is moving along. You have status or settlement conferences with the court every 4 to 6 weeks. The attorneys appear. They let the judge know what's going on. You try to get some input for the judge as to how to resolve the case. And then that helps you with your settlement negotiations. But sometimes you just can't settle them, which means you get a trial date. And trial dates are often, 2-3 months. They're set 2 to 3 months after you're in court. So, and that's just because of the court calendar. So it's very frustrating for a lot of these guys going through divorce, which is understandable because it's a long process, and a lot of it just has to do with the court's calendar.
Yep. And so any, parting thoughts for guys, she's filed. Anything that they should think about other than what we've spoken about that you think is important for guys to just, whether even information gathering and research?
I think if she's filed and and you are surprised by that, I think the first thing should be go meet with lawyers. And I'm saying more than one. I mean, I'm confident in Cordell that you can come and you would feel confident with any Cordell attorney that you would speak with. But it's important to find an attorney that you feel like is going to have your back and that's going to be able to get you through this process. You may not mesh well with an attorney you meet with, but you feel like you have to hire them because, he's the first person that you met and I just want to get the process started. I would really advise not to do that, to find the attorney that you feel like is going to work for your best interests. And then once you have that attorney, don't expect anything less. I mean, we're here to work for you. And, you're paying us to work for you. So demand the best out of your lawyer, and it'll make the process better. You'll get better results.
Great. It's good stuff. Thanks, Aaron. Appreciate it. I know everyone out there got some good tips and ideas and information with regards to, my wife's filed and now what? And so hope you found it useful. I know I did. It's always good to talk through and get some good ideas. Next time, we're going to talk about part 3, and I hope you all join us for part 3, which is kind of a step-by-step discussion about perhaps the process and going through the details of the process that we just kind of went through quickly, but really talk about some of the deadlines and some of the critical things that you can do along the way to try to help and further your case. So I hope you join us next time for part 3. If you have any more questions or you want more information, certainly go on the website, go to CordellCordell.com, dadsdivorce.com, mensdivorce.com, or obviously, if you need to talk to us, you can give us a call at 866-DADS-LAW. Until next time, we'll see you on part 3.
Thank you for listening to the Men's Divorce Podcast presented by Cordell & Cordell. To schedule your appointment with a Cordell & Cordell attorney, please visit CordellCordell.com or call us at 1-866-DADS-LAW. Also, make sure to visit our partner websites, mensdivorce.com and dadsdivorce.com, and download our free Men's Divorce Source app available on the App Store for the latest divorce news and resources. Cordell & Cordell, a partner men can count on.